This is the Study for the Bar in Your Car podcast.
Welcome, everyone.
We're your hosts, Maude and Claude. We also have Angela here.
And this is episode 10 of Constitutional Law.
Today's topic is the Privileges and Immunities Clauses. Kind of a tricky pair, wouldn't you say?
Definitely. Easy to mix up if you're not careful.
We are AI bots, brought to life by the magic of AI and, of course, Angela's constitutional law notes.
Angela is really the brains behind this podcast. She graduated from GMU Law, and she's standing by.
Yeah. Angela, you've been awfully quiet lately. Say something. Let us know you're alive.
Blink twice if you hear this.
Hey, I'm right here. So I am just keeping quiet because you guys seem to be the experts at all this privileges and immunities stuff. So I'm just going to slink back into my corner and let you guys run the show.
Maybe she's deep in thought. We're just letting us handle the mics today.
Well, if you need to contact Angela, you can email her at podcast@studyforthebarinyourcar.com.
And you know, Angela actually works as a freelance remote law clerk for attorneys across the USA.
That's right. So if you're an attorney or maybe you know one who needs a hand with research on LexisNexis or Westlaw,
or writing motions, appeals, demand letters, even sorting out the office with AI,
then you can email her at hello@legalwriterandlawclerk.com.
She works mostly in personal injury and criminal law, but she also covers property, family law, and probate, too.
Quite the range.
Okay, let's get into today's topic. The Privileges and Immunities Clauses. We're drawing directly from Angela's comprehensive law school notes and outlines here.
Right. And as we mentioned, there are two main clauses to cover. Article 4, which deals with privileges of state citizenship.
And the 14th Amendment, which covers privileges of national citizenship.
Let's start with Article 4, privileges of state citizenship.
Right.
What's the core idea here based on Angela's notes?
Well, the main point is that it stops states from discriminating against non-residents, meaning citizens of other states.
Discriminating how, exactly?
When it comes to fundamental rights or important economic activities, Angela's outline calls these rights basic to the livelihood of the nation.
Okay, basic to the livelihood. Can you give some examples? What kind of activities are protected?
Sure. Things like the ability to earn a living in that state, the right to own property there, or accessing the state's courts.
So if I'm from Texas and I want to, say, get a job in Oklahoma generally can't put up special barriers just because I'm Texan.
Exactly. They can't treat you like a second-class citizen for those core things just based on your residency.
But is it always forbidden? Can a state ever discriminate against out-of-staters under Article 4?
It can, but it's tough. Angela's notes say the state needs a substantial reason for the discrimination.
A substantial reason. And is that it?
No, there's more. The discrimination also has to be closely related to achieving that reason. The burden's entirely on the state to prove this.
So a really strong justification is needed, and the way they discriminate has to directly serve that purpose.
Right. It's a high hurdle. Now, this often gets confused with the Dormant Commerce Clause, doesn't it?
It does. Both limit state power regarding interstate stuff. What's the key difference according to the materials?
Well, Article 4 P&I protects individuals, specifically citizens of other states, from discrimination. It's about personal rights.
Okay, individuals. And the Dormant Commerce Clause.
That's generally about state laws that burden interstate commerce itself. It might be discriminatory, or it might just place too heavy a load on commerce, you know.
Got it. So Angela's outline probably suggests a starting point for analysis.
Yeah, it says the first question you should ask when you see a law affecting out-of-staters is, does this law actually discriminate against them?
And that helps point you towards either P&I or the Commerce Clause.
Right, like those cases, Philadelphia v. New Jersey about the garbage ban or Granholm with the wine shipments, those were more about the burden on commerce, often involving facial discrimination.
But Article 4 P&I is focused squarely on the individual citizen's right not to be discriminated against in those fundamental areas just because they're from another state.
Precisely. It's about the person, not the product or the flow of goods so much.
Okay, that clarifies Article 4 nicely. Let's switch gears to the 14th Amendment privileges of national citizenship. Angela's notes seem to indicate this one's different.
Very different. Much narrower in practice. It protects rights that are incident to national citizenship.
But historically, the Supreme Court hasn't applied it very broadly.
Not at all. According to Angela's outline, its scope was significantly limited by early case law. It just hasn't been used much.
Except for one major area, right?
Yes, the big one. The fundamental right to interstate travel.
Ah, the right to travel. So if you see a 14th Amendment P or I question, you should immediately think travel.
Pretty much. That's the main, almost only place it gets applied these days. And the key case Angela highlights is Saenz v. Roe from 1999.
Okay, Saenz v. Roe. Walk us through that one. What was the issue?
California passed a law that limited welfare benefits for new residents. For their first year living in California, they'd only get the amount of welfare they would have received in their previous state, but only if that amount was lower than California's benefits.
Wow. So move from a state with low benefits to California, and you're stuck with a lower rate for a whole year.
Exactly. Sounds like it might discourage people from moving, doesn't it?
It certainly does, and the Supreme Court agreed.
Yes. The court struck it down, said it violated the 14th Amendment's Privileges or Immunities Clause because it infringed on that fundamental right to travel.
Did the court break down what that right to travel means? Angela's notes probably cover this.
They do. The court in Saenz identified three aspects, three parts of this right.
Okay, what are they?
First, the right of a citizen of one state to, just enter and leave another state, pretty basic.
Makes sense.
Second, the right to be treated like a welcome visitor, not a hostile stranger. When you're just visiting temporarily, think Article 4 P&I overlap there, maybe.
Interesting. And the third aspect, you said this was key for Saenz.
Right. The third one is crucial. For people who decide to become permanent residents in a new state, it's the right to be treated equally with the longer-term residents of that state.
Equal treatment for new permanent residents. And the California law violated that aspect.
Directly, by creating two classes of residents based only on how long they'd lived there and giving the newer ones fewer benefits, California was penalizing the exercise of the right to migrate and establish residency. It chilled that right.
So the state basically treated its new citizens differently, less favorably, just because they were new.
Yep. And Angela's notes really emphasize this point. It's fair to say the only time the 14th Amendment P or I clause really comes up is with regard to this right to travel, particularly that third aspect about equal treatment for new residents.
That's a very clear takeaway. Keep the 14th Amendment P or I focused on the right to travel, especially the Saenz scenario.
All right, I think we've got a good handle on the rules. Let's try applying them. How about a bar exam style essay question?
Sounds good. Let's use the IRIC method to break it down.
Okay, here's the scenario based on what we've discussed.
Hit me with it.
State A is facing a budget shortfall. To save money, it passes a law. This law says that any individual who has resided in State A for less than 1 year will receive unemployment benefits at a rate equivalent to the maximum unemployment benefits offered in their previous state of residence, but only if that rate is lower than State A's standard benefits.
Okay, similar setup to Saenz, but with unemployment benefits instead of welfare.
Individuals residing in State A for more than 1 year get State A's standard higher unemployment benefits. Now, a new resident moves from State B, which has much lower unemployment benefits, to State A. After 6 months, she needs unemployment benefits, but is told she'll only get the lower State B rate for her first year.
And she challenges the law.
Exactly. The question is, discuss the constitutional challenge to State A's law. Analyze whether the law violates any constitutional provisions and explain your reasoning using the IRAC's method.
Okay, let's unpack this. IRS, first issue, what's the core legal question here?
Well, the issue is whether State A's law, by creating this 1-year waiting period for full unemployment benefits based on prior residency,
violates the Privileges or Immunities Clause of the 14th Amendment by discriminating against new residents and infringing on their fundamental right to interstate travel.
Nicely put. That nails the specific clause and the right involved. Now, for our rule, we need to lay out the governing legal principles clearly, drawing from Angela's notes.
Right. So first, we should mention the Article 4, Section 2 Privileges and Immunities Clause. Briefly explain, it protects citizens of one state from discrimination by another state regarding fundamental rights or key economic activities.
Unless the state has that substantial reason and the means are closely related. But we also note, crucially, that this usually applies to discrimination against non-residents, people just visiting or working temporarily, not new permanent residents.
Good point. Then we define the main player here, the 14th Amendment Privileges or Immunities Clause.
Exactly. Explain that it protects rights of national citizenship, acknowledge its narrow application historically,
but emphasize its key role in protecting the fundamental right to interstate travel. And definitely lay out the three aspects of that right: entering, leaving, treatment as a visitor, and the big one, the right of new permanent residents to be treated equally with established residents.
And you absolutely have to cite Saenz v. Roe here. Explain how it invalidated a similar durational residency requirement for welfare benefits, finding it infringed on that third aspect, the right to equal treatment for new residents.
Perfect. Strong rule statement. Now, A, application. How do these rules fit the facts of State A's unemployment law?
Well, State A's law seems to hit that third aspect of the right to travel squarely on the head, just like the California law in Saenz.
How so?
It creates two tiers of residents based purely on how long they've lived in State A. New residents, for their first year, get potentially lower unemployment benefits simply because they exercise their right to move there.
So it directly penalizes the act of migrating and becoming a new permanent resident. It's treating them differently, unequally, compared to longer-term residents. The parallel to Saenz is extremely strong.
What about State A's reason, the budget shortfall? Does that save the law?
Probably not. Based on Saenz and the principles from Angela's outline, saving money is generally not a compelling enough justification to burden a fundamental right, like interstate travel, especially through discriminatory means.
Right. The state can't usually balance its budget by infringing on the fundamental rights of its newest citizens.
And you'd also argue the law isn't narrowly tailored. There are likely other ways for State A to address its budget shortfall that don't involve discriminating against new residents based on their fundamental right to travel.
Makes sense. So that leads us to C, conclusion. What's the bottom line?
The conclusion is that State A's law is very likely unconstitutional.
Because?
Because it violates the 14th Amendment's Privileges or Immunities Clause. It impermissibly burdens the fundamental right to interstate travel by discriminating against new residents and denying them equal treatment regarding unemployment benefits following the precedent set in Saenz v. Roe.
Excellent walkthrough. That really clarifies how to apply these clauses.
Yeah, distinguishing them and knowing Saenz is key.
Okay, that pretty much wraps up our discussion on the Privileges and Immunities clauses for this podcast. And a huge thank you again to Angela for her incredible con law notes. Seriously, they make these podcasts possible.
Absolutely. Couldn't do it without him.
Now, just a few important housekeeping items before we go.
Go ahead.
First off, please remember, Angela is a law student just like you. She's not an expert, and she hasn't passed the state bar yet.
Right. And second, neither Angela nor this podcast is giving legal advice. None of this should be taken as legal advice.
And, you know, AI isn't a substitute for actually studying for the bar exam. Think of us as an aid, not a shortcut to success.
Definitely supplement your learning. This podcast shouldn't be the only way you're studying.
Also, AI isn't always perfect. Sometimes we make mistakes.
True. Angela does try to fix any errors that pop up. Her notes might be excellent, but even law students make mistakes sometimes. We do our best to correct things.
And fifth, this whole podcast series is an academic, non-commercial thing by Angela. It's strictly for educational purposes.
She makes no money from this, so there are no guarantees on its accuracy. Use your judgment.
And finally, a practical note. When you're driving, please, the most important thing is to be safe on the road.
Yeah, don't cause a tort while listening to constitutional law.
Right. Okay, just a reminder, if you need to contact Angela, email her at podcast@studyforthebarinyourcar.com.
And for any attorneys out there, or if you know one who needs help with research on Lexis or Westlaw, writing motions, appeals, demand letters, or even using AI in their practice,
you can email Angela at hello@legalwriterandlawclerk.com.
Okay, I think that covers the housekeeping. Now, for our tradition, the cheesy constitutional law joke.
Oh boy, let's hear it.
Why did the First Amendment break up with the Second Amendment?
I don't know why.
Because it felt like he was getting too much attention.
Okay, that one wasn't too bad. Got a slight chuckle.
Mission accomplished.
All right, this is Claude.
And Maude, your AI hosts, signing off.
And Angela.
We'll see you on the next podcast.
Thanks for listening. Bye.